How do you get charged with invasion of privacy? There are a number of ways to get charged with invasion of privacy. One of the most common ways that we see a lot is that there was an active no contact order or a protective order in place. A no contact order is usually an order that the judge basically is ordering you as a defendant on a criminal case not to have contact with certain individuals. And these individuals could be individuals you've never even heard of. They could be civilian witnesses or alleged victims on your case. Sometimes they could also be people who you do know. In a lot of domestic violence cases, it could be a no contact order against your spouse or a family or household member. In a court order, they could also order that you do not have any contact with that person. And they'll tell you, don't have any contact with them directly or indirectly. Meaning don't talk to them, don't call them yourself, don't ask anyone else to contact them for you. And this includes showing up to their place and talking to them, calling them on the phone, using social media to contact them and sending them texts, sending them Snapchats, going on Instagram and contacting them. Even liking a post on Facebook is technically considered contact by the court. That's a no contact order, but another thing that comes with a no contact order is that you're not allowed to have any firearms. Even if you're legally allowed to carry, if you have firearms or ammunition at your home, you've got to get rid of them if you have a no contact order. Technically, you're not supposed to have them under a no contact order. A no contact order are basically statewide. So not only statewide, they're actually countrywide. And it's not a situation where you have a no contact order and it gets an individual in Indiana and then you go, okay, well, today I'm going to go to Illinois and I'll contact them from Illinois and I can't get in trouble with that. Yes, you can. It's still a no contact order. It just doesn't extend to the state of Indiana. So if you contact somebody under a no contact order or a protective order and you know about that no contact order, because either you were served with a protective order or you were in an open court and you were read that no contact order by a judge, regardless if you sign the order or not, you're on notice that there's an active no contact order. So if you contact that individual, you can be charged with invasion of privacy. Now, invasion of privacy starts off as a Class A misdemeanor and it can carry a penalty of up to 1 year in jail or a fine of $5,000. Invasion of privacy is also enhanceable. So if you have a misdemeanor invasion of privacy conviction and you get arrested for invasion of privacy in the future, that could be enhanced to a level 6 felony because you had a prior. So it's very important to not violate the no contact order or protective orders because you could be charged with this offense. You have no idea how many times people mess up their own cases, domestic violence related cases or other criminal cases by contacting people who they're not supposed to. Now your attorney is allowed to contact witnesses, alleged victims on your behalf, things like that. So if you need to contact someone to help with your defense, you need an attorney who will do that for you. So call us at the Marc Lopez Law Firm at 317-632-3642 and always remember, plead the fifth.